It's been asked a ton of why do they make us go to arbitration? And the reason's pretty simple. Number one, they want to avoid a jury. They don't want a local jury getting all mad at them and hitting them for a ton of damages, number one. Number two, they want to avoid class action lawsuits. They don't want to have some enterprising plaintiff's lawyer file a class action with all 200,000 of their customers or how many they have, and basically becoming a threat to their existence. So they force you into, as a consumer, they force you into an arbitration clause. In arbitration, you can't do a class action. You can't do a collective action. You can only sue for your own matter. You can't sue along with anybody else. You only get a judge. You don't get a jury. And there's all these other restrictions that are put on you when you agree to an arbitration clause. It's in essence where you hire a private judge. That's all it really is. There's two organizations in the country that are the major ones. It's called AAA, the American Arbitration Association, and JAMS. JAMS is Judicial Arbitration and Mediation Service, and all of their arbitrators are retired judges. So these are great organizations. They're not shills for the industry or anything. They're legit, and they will give you a good result if you put on the right case. Now, here's where we've turned that around and used that against them. In order to make the arbitration clause enforceable, the courts have said you can't make a consumer sign an unconscionable arbitration clause. And if they put all of the arbitration expense on you, the consumer, that's been held to be unenforceable. So all of these arbitration clauses are written to where you, the consumer, only have to pay at the most $250 of the original filing fee. Here's what they don't know, or you don't know, or they don't tell anybody. The arbitration fee at JAMS, the initial fee is $2,000 plus a $5,000 deposit for the arbitrator. So to get a case started, we pay $250, they pay $6,750, which is just a giant number. And on top of that, they have to pay outside counsel. On top of that, they have to pay a $5,000 to $8,000 a day fee for the arbitrator when they actually do the arbitration, and 100% of that gets paid by the business. I think what they never thought was that one law firm or one group would ever get a significant number of cases together to make it really, really hurt for them to be in individual arbitrations. And so our firm right now, this video has been made in December of 2024. We have over 500 cases right now, which collectively is over $3.5 million worth of filing fees that these lenders are going to have to pay because we're in the forum they chose. And so we're trying to turn it around, and it is being effective. We're using their own rules against them. And that's why I love being in arbitration, because it inflicts maximum pain on the defendants, and we're still getting the results we want. And so it's actually turned out it was meant to protect them against class actions, which I guess it did. But if you get enough of them, it's going to actually cost them more than a class action if we get the right number of people. So if you want to be part of the movement, want to be part of what we're doing, want to be part of making change in the industry, the only way they'll change how they work is if we make it painful and we make it costly and we make it expensive. So that is what we're doing. That is our mission. That is our goal. And we would love to represent you in that process, at the same time getting a great result for our clients.